All right, everybody, we are going to go forward with Chapter 8, Researching E-Discovery Case Law, where we'll describe the appeals process, describe the commercial and free resources for researching a case law, explain the implication of civil case law and e-discovery, including email issues, litigation holds, explain how criminal case law applies to e-discovery, summarize the issues and multi-jurisdictional and international cases. For Chapter 8, we'll be going through our PowerPoint or our online lecture. You'll also be cast with Chapter 8 Forum, where we'll do one discussion and one reply, just like you've been doing. But in this case here, we're going to basically illustrate a flaw with typewritten media or hard copy or intangible copies like your EPUB or eText if you purchase the PDF or EPUB version of the textbook. So during your casework, you notice that each case sets precedent for future cases down the line. If a case sets precedent, then each subsequent case can then refer to its prior precedented case and further enforce its validity in the ever-changing legislative landscape. By now, I'm sure you've noticed the copyright date on your textbook or discussion slides. It's difficult to keep up with material that is in print. As it's tangible or digital copy, the words do not update as new laws come out. Pay attention to slide 3 on this week's discussion, specifically smartphones, text messaging, Skype, and Google Plus introduce situations for which there's no case law applies. That is not true anymore. As of this recording, November 27, 2017, you'll notice that there are a multitude of cases that have adopted smartphones, text messaging, Skype, Google Plus, iPhones in the media or in the news that dictate today's new requirements or precedences. So during your discussion, do some research defining legal precedences where smartphones, text messaging, Skype, Google Plus, and other methods are being used in today's legal system. Make sure your post meets the required length and the reply meets the required length as well. Don't forget your MLA formatting as to where you got your information or resources. It's important to note that as we get closer to the end of this semester, we don't want to fall or get behind, as well as sort of relax on our sort of setups that we have for discussion. So don't go less than the required word length that we've defined early in the class. You'll also go through Project 8-4, which is where we research Columbia Pictures versus Eindel and Burnell. You'll notice that that is not a link there, but if you look in your Google Drive link that I put in resource earlier, you'll find that case, or you can research it other methods. Make sure you use the FEAR Act method. If you don't remember FEAR Act, that's Chapter 2, page 38, and write a 1 to 2 page summary indicating the court's decision and why they issued it, preserving server's RAM. You'll then go through Chapter 8 review questions, Chapter 8 review questions, which will then unlock Chapter 8 quiz. So with that said, let's go ahead and get started on our Chapter 8 discussion. Or lecture for that matter. All right, researching e-discovery case law with our objectives that we described earlier. Common law countries use case law as a guide when there are no existing statutes that apply specifically to a case. Case law determines how laws are applied and is based on previous rulings. So this is slide 3, where we talked about smartphones, text messaging, Skype, Google Plus, any cloud technologies, or even future or relevant technologies as well. So it's important to understand the legal appeals process. When reading case law, it helps to understand how the U.S. court system is organized. The judicial branch is that of the U.S. federal government, and it's represented in all 50 states. Each state has its own hierarchy of courts, ending in a state Supreme Court for appeals. Each state has federal courts that address issues dealing with the U.S. Constitution, bankruptcies, treaties, etc. 94 federal jurisdiction or federal districts are grouped into 12 circuit courts known as appellate courts. Each state has at least one federal district court. Cases heard in district courts feed into the appellate court if challenged. At the top level is the U.S. Supreme Court, has the final say in matters of the U.S. Constitution. That's not to say that you can't request your case move forward to the Supreme Court. It's also not to say that they won't always answer you. It's possible that you can be in a situation where your federal or your state level doesn't meet the verdict that you want, and the Supreme Court at the state level doesn't meet the verdict that you want. So your only choice is to go to the U.S. Supreme Court. They do not hear all cases. There are statistics on how many cases they do review, and I think it's somewhere under the neighborhood of like 20%. It's definitely under 20%. The exact amount I do not remember. You could look it up if you choose. As we see, here's our 94 districts, then goes to our 10th Circuit, and we're in Texas, so we live in the 5th Circuit Court with Louisiana, Missouri, and Texas. If plaintiffs and defendants agree with the judge or jury's verdict, they can take the case to the Court of Appeals or District Court. The appellate has to approve the legal aspect of the case is incorrect. When addressing e-discovery, the appeal might be based on the overly broad or discovery order or use of cell phone data. Appeals can be written as briefs or oral arguments. Two leaders in the legal databases is the Westlaw and LexisNexis. LexisNexis acquired several legal archives and publishers over the years since 1800s. In the 1970s, the Ohio State Bar contracted DataCorp to create a text retrieval system, later purchased by Mead Corporation as Lexis. The Nexus portion was created for news media around the same time. In 1997, it launched the internet search engine for legal data. Westlaw grew along different lines than LexisNexis. John West founded a publishing company in 1872, created the American Digest system, categorizes by topic and key number. He started the Federal Reporter in 1880 to publish decisions of federal district and circuit courts. The American Bar Association endorsed his method of sorted cases in 1997. The Thomas Reuters Publishing purchased John West Company in 1996 and retained the name Westlaw. Most universities and community colleges have access to Westlaw or other legal search engines depending on the school. The subscription enables you to search for the appeals and other related cases. Using Westlaw is straightforward. There are two types of searches, by a specific case or by topic. Using legal databases, if you do not have access to Westlaw, your free legal researchers' websites are available. FindLaw is an example. The Electronic Discovery Law or e-discovery law. American Lawyer Media created law.com. And vendors such as Kroll OnTrack have databases and documents with summaries of hundreds of cases. So there's a lot of case law that we'll be going through here. And we're not going to go through them in great detail because it would take just too long, but we'll go over the case itself and why it's important. The case of Donato Aponte, Nevada, and the plaintiffs, Nalco Chem V Chemical versus Nalco Chemical Company in 2010 involved e-discovery requests going unfilled or being challenged or being too broad. The monetary damages for the failure to deliver weren't imposed because neither party was found at fault. The FRCP Section 34, there's going to be a lot of FRCP sections in all of these. We won't go into reading each one because, I mean, they're right here. So the Legal Landmark Foundation versus the Environmental Protection Agency, where the EPA destroyed backup tapes, reformatted hard drives, and deleted emails. The EPA was fined on this case. Email and privacy, we've got Peskov versus Faber in 2006. The defendant was charged in diverting company funds for his own personal use. The emails went deleted or were missing, and then $33,000 in forensics costs were estimated, and the the defendant in this case was ruled to pay the vendor's costs. So email represents a large portion of electronic data presented in court. Establishing policies on how they're used and e-business email accounts are critical. If employees use their business emails for personal correspondence, does the content belong to the employee or the employer? The courts have two approaches for this: content or context. The content approach is the employer is allowed to monitor any emails related to the regular course of businesses, but cannot monitor personal emails. The monitoring system might check for malware, perhaps scan for particular words. The context approach, the court tries to determine whether an employer had a legitimate cause to monitor employees' email. An internal investigation of an employee has been started. The court might determine that reading personal email was warranted. So, just for future reference, the company that you work in may have established such approaches, but the court dictates only the two following. Now, if you agree to a data and privacy agreement with your employer, many of them today dictate specifically that you are not to use email for personal usage. And there's a variety of thought as to why this is. Not that your employer is trying to be mean, but that when you register for something like, I'll just make up a website, smartdeals.com, and you use your business email account in it, and you use a common password, say maybe your corporate email login password, you then have committed a couple of cardinal sins, really. You have shared out your password that is similar to your work password. On top of that, if that company that's not held under your legal representation or legal laws and corporate structure, if your password is breached, like over at this Shop Deals or Smart Deals, say for example, Target, for example, had their big privacy breach in I think it was 2013, where customer data was leaked to online hackers and sold on Black Web and Deep Web. It's possible that your company could face litigation or possible suits because you left your password the same, and possibly exposing any business critical information to people as well, because, hey, your email address is there. Guess how easy it is to log into an email address once they have your password. All right, the contempt approach to email privacy. Oh, no, we already went over content and context. So the Electronic Communications Privacy Act, ECPA, addresses online privacy, specifically when data is transit. Created in 1986, changes have been made and recommended because of advancements. In a Wired article in 2012, a Google transparency result showed how many user data requests the government makes annually. Warrants to see this information aren't necessary, only a subpoena. So under this act, emails older than 180 days do not require a warrant, but emails more recent than 180 days do. So that's about 6 months. The EPA and Stored Communications Acts were created when storage was costly and space was at a premium. Most emails are deleted shortly after receipt at that time. With advantage in stored media, email are now retained for years. On top of that, compression and storage capacities have changed as well. Companies should train employees to be aware of these regulations to help safeguard their privacy. In the case of Einstein and Boyd versus 357 LLC and the Corconian Group, resulted in sanctions that the defendant purposely misled prosecutors about the existence of certain emails. Intentional destruction of ESI and deleting emails occurred. The case upheld a company's obligation to retain that evidence when a litigation hold is in place. The EEOC versus JP Morgan Chase 2013 was charged, and JP Morgan Chase was charged with deliberately continuing scheduled purges when which included data needed in the case. The judge dismissed the case. The sanctions were minimal. When a small fine is compared with a potentially high judgment, some will choose to destroy ESI until penalties adequately address the consequences. Some will continue ignoring litigation holds on ESI. In criminal e-discovery, the financial burden is on the government. If litigation is anticipated and ESI destroyed, obstruction of justice charges can be filed. In the case of United States versus Suarez in 2010, the FBI failed to preserve text messages from a key witness. The defendant used a civil e-discovery standard that text messages were critical, and his case would suffer without him. As a result, the jury acquitted him. In criminal e-discovery, financial burden. Oh, this is a repeat of the same slide. That's a fluke in this slide set. 1 out of 8 isn't so bad, right? The Joint Electronic Technology Working Group established recommendations for e-discovery in federal criminal cases, explains how to plan for criminal e-discovery procedures, includes a checklist with items such as determining whether classified information or trade secrets are involved. Also addresses legacy data, wiretaps, paper documents, and other matters. For international law in multi-jurisdictional cases, we need to be aware of the laws of each nation or jurisdiction in which they do business. A U.S.-based company was investigating an employee who lived in a branch in the European Union. Investigator used a VPN terminal to examine the business computer. When an investigator was sent to the European Union to retrieve the hard drive, he was arrested for violating that country's privacy laws. International law in multi-jurisdictional cases rely on the UN model for international and commercial arbitration, created to address e-commerce and commerce, to give standardization to international business law. One of its goals is to address the differences in laws that international cases aren't halted because of these legal differences. The United Nations Economic Commission for Europe, the UN model law establishes the requirements for electronic data and interchangeable data between countries. Many countries haven't embraced e-discovery in the same manner as in the US, caused partly by more restrictive privacy laws and narrow focus in discovery orders. Many countries are looking to the US for guidance in handling complexities of dealing with electronic evidence. Litigation holds in the meet and confer are now required in Nova Scotia. The International Competition Network formed with the goal of standardizing its members and investigative procedures. The organization published the Anti-Cartel Enforcement Manual, which describes processes for gathering digital evidence in an organization, handling privileged and private data, training staff, and handling data stored off-site. One chapter focuses on search and seizure of company premises when a search warrant is needed and how to prepare for a search, how to put together a team, how to conduct a search, and search arrested peoples. The manual is thorough in coverage of different countries involved and the requirement for investigating an antitrust complaint involving ESI. E-discovery database was created to help e-discovery students and practitioners research state, province, and country laws that might apply to a case. The purpose of this database is to create a resource that's detailed enough to help investigators and lawyers working on cases involving digital evidence. The database's original table design starts at the country level and works down to specific case law. The database is designed to compare state and country, state provenance and country laws. It begins at the country law, and where you enter a country name and code, and you browse by the country's code. Countries might have multiple jurisdictions, states and provinces that have different civil laws. After entering provinces, states, and related laws, you can look up their applicable state law. So in the table that we're going to go over now, and this is figure 8.7, the PK is the primary level, the FK is the foreign key, and the country table consists of two fields for country codes. The state ID is typically made of country code and state abbreviation, so USCA. So our entire ruling set here, where our PK is country code. So rule type IDs, case tracking numbers, common search criteria, search terminologies, rules and subsections, state provenance, and state rules. The state province table reflects how laws vary between states and provinces in a country. You can interrelated civil and criminal laws in the state can be mapped to federal laws. The case law table also shows how cases are linked to one country to another, related laws, key search terms. Use this table to look up cases that might be similar to the one you're investigating. Another table is added for states with their own civil, criminal, and evidentiary rules. It's called the state rules. Many states have similar rules numbers. The state rule ID is an auto number used as the key field. One-to-one, one-to-many relationship, the state province table can be set up. The state rule field is used to describe a rule's function. After several cases have been entered, it's clear that more detail is needed. A table for sections and subsections of federal or country laws was created. So, in summation, the judicial branch of the U.S. government is represented in all 50 states. Each state has its own hierarchy of courts, ending in a state Supreme Court for appeals. The number of online resources for e-discovery is growing. The biggest challenge of e-discovery is litigation holds because they're often ignored. As a result, ESI is deleted. The issue of privacy in email continues to be a concern when creating company policies in the United States and other countries. When civil cases become criminal cases, the rights of the individual in Rule 41 of the FRCP or FRCRP related to search and seizure apply. The Electronic Communications Privacy Act doesn't adequately address issues related to the age of the email, data stored remotely, and other matters introduced as a result of cloud storage. And that will stop us for week 8. We'll continue on week 9, and then we'll move on to our final exam.